Imagine you're building something incredible from the ground up, maybe a new business, a major project.
Or even just planning a big trip with friends.
Exactly. Every step, every decision, it relies on agreements. But what makes those agreements actually stick? What turns a casual, yeah, sounds good, into, a legally binding commitment that you can rely on? Today, we're going to lay the foundational legal bricks for exactly that. We're focusing on something that underpins almost everything we do.
Yeah.
The formation of a contract.
Our mission today is to walk you through the absolute first step in contract law, contract formation.
And this isn't just dry theory, is it?
Not at all. It's the very bedrock, the foundation upon which all other contractual principles are built. So getting this right is absolutely crucial for your success.
And to make sure we're giving you the most practical, kind of no-nonsense insights, we've distilled knowledge from some truly excellent SQE-focused materials.
Good stuff.
We're going straight to the black letter law. Those fundamental core rules that dictate how contracts operate. Then we'll immediately see how real-world case precedent, actual court decisions, helps us understand precisely how those rules play out in practice.
Because the theory is one thing, but seeing it applied is key.
Our goal is clarity and direct application, helping you not just understand, but truly apply these concepts to those tricky exam questions.
Precisely. In English law, for an agreement to be considered a legally binding contract, it needs three essential elements. I like to think of them as the three legs of a sturdy stool.
Okay, a three-legged stool, I like that analogy.
Those legs are firstly an agreement, secondly an intention to create legal relations, and thirdly, something we call consideration. Now, today we're going to really dig deep into the first leg, the agreement.
Got it.
And this means breaking down its two core components, offer and acceptance.
Okay, perfect. Let's start then with the very first building block, the absolute beginning of any contract, the offer. On the surface, it sounds simple, doesn't it? I offer to sell you my car.
Seems straightforward.
But in the eyes of the law, it's far more precise than that. Our sources define an offer as an expression of willingness to contract on specified terms.
Made with the intention that it is to become legally binding as soon as it is accepted by the person to whom it is addressed. That last part is key.
It really is. And this definition immediately brings us to a fundamental concept in contract law, the objective test.
Ah, yes, crucial. When courts are asked to decide if an offer was truly made, they don't try to be mind readers. They don't attempt to figure out what the person making the offer was secretly thinking or really intended deep down. Instead, they apply an objective test. This means they look at the entire interaction, the words used, the conduct, the surrounding circumstances from the perspective of a reasonable person.
A reasonable person, okay.
What would a reasonable, ordinary, and informed individual conclude about the party's intentions based on what they actually said and did?
That makes perfect sense. It's like you can't just casually say, I'll sell you my house for a tenner, and then try to back out later by claiming you were just joking.
Right.
If a reasonable person, given the context, would have genuinely believed you were serious, it brings certainty, doesn't it?
It absolutely does. It underpins commercial reliability. But you mentioned there's a rare exception to this objective rule, a time when the court might actually look at someone's subjective state of mind.
Yes, it's quite rare, but it's an important nuance. The subjective test can apply where the offeree, that's the person receiving the offer, knew, or ought to have known, that the offerer had made a significant mistake about the terms. So drilling down, what are the non-negotiable key requirements for any communication to be considered a valid offer in the first place?
Okay, three key things. First and foremost, an offer must be clear and certain. There can be absolutely no ambiguity or uncertainty in its terms. It needs to be precise enough that no further clarification is required from the offerer. Secondly, it must be addressed, meaning it needs to be specifically directed from the offerer to a particular person, a group of people, or maybe even the world at large.
Like in a reward case.
Precisely. But it can't just be a general statement floating in the ether, not directed at anyone specific who could accept.
Okay. Clear, certain, addressed. What's the third?
And thirdly, perhaps most importantly, it must demonstrate an intention to enter a legal relationship. This is truly crucial.
The intention bit again.
Yes. Our sources highlight that words like will or must strongly imply a commitment, a clear intention to be immediately bound if accepted.
Right, like, I will sell you my car for 5,000 pounds.
Exactly. However, if the communication uses softer language like may or I am thinking of selling or I might consider, it often suggests flexibility. It signals an openness to negotiation, and crucially, a lack of immediate intent to be legally bound right then and there.
It's a subtle but powerful distinction, isn't it? That difference between will and may.
Huge difference. Definitely one to flag for anyone studying for the SQE. It can genuinely be the difference between a binding agreement and just, well, a chat about possibilities.
And this brings us perfectly to another critical, frequently tested distinction: offer versus invitation to treat, ITT. My mind immediately goes to a shop window display when I think of this. Is that right?
That's a great instinct because it's a classic example. The core idea here is that not every communication proposing a deal is an actual offer ready to be accepted.
Okay.
Many are simply a preliminary step, what we call an invitation to treat. This isn't a commitment to sell, it's more like an invitation for others to make you an offer. It expresses a willingness to open negotiations, not to be immediately bound.
Like saying, my car is up for grabs, rather than, I offer my car for $5K.
Precisely. Identifying this distinction is absolutely vital, isn't it?
It truly is, because it determines whether a contract can even begin to form.
Right. If a communication is just an ITT, then no one can accept it to create a contract. All they can do is make an offer in response to the invitation.
Which the original party can then choose to accept or reject.
Exactly. It flips the roles.
So let's walk through some common scenarios, seeing how the general rules apply to ITTs. What about adverts?
Okay. Advertisements. The general rule for advertisements, whether online or in print, is that they are generally considered an ITT, not an offer.
And the logic behind that.
It's purely practical. Imagine if every advertisement for a discounted TV was a binding offer. The advertiser would be legally obligated to supply every single person who accepted, potentially thousands.
They'd run out of stock instantly.
Exactly. It would lead to endless liability far beyond their available stock. It just wouldn't be commercially viable. So the law says the advert is usually just inviting you to make an offer to buy.
Okay, that makes sense. What about goods in shops? Like that handbag in the window we mentioned?
Same principle.
Yeah.
The display of goods in shops, whether it's a handbag in a window or items on a supermarket shelf, is generally an ITT.
So when I take my milk to the checkout, I'm making the offer.
Yes. The offer is made by the customer when they take the item to the till and propose to buy it. The shopkeeper or the cashier then has the right to accept or reject that offer.
Which they might do if it's mispriced, for example.
Precisely. Or if they suspect theft, or if it's age-restricted goods and you don't have ID, they are accepting your offer at the till.
And this principle extends online, doesn't it? Websites showing products for sale.
Absolutely. Websites displaying goods generally follow the same rule. They're treated as ITTs, like a digital shop window.
So when I click Add to Cart and Buy Now,
your order is the actual offer to purchase. The website or seller then accepts or rejects it, usually through an order confirmation email or by dispatching the goods.
Okay. What about auctions?
In auction sales, the auctioneer's request for bids is an ITT. They're inviting offers. Each bid made by a potential buyer is an individual offer.
And the auctioneer accepts the winning offer.
By tapping their hammer. That's the moment of acceptance. The contract isn't formed until the hammer falls. Until then, the bidder can withdraw their bid, and the auctioneer can withdraw the lot.
Makes sense.
Yeah.
And finally, invitations to tender, like asking for quotes for building work.
Yes, invitations to tender, which are formal requests for quotes or bids for a specific project, are also generally ITTs. The person inviting tenders is simply soliciting offers. They then review the submitted tenders, which are the offers, and decide whether to accept any of them. They aren't usually bound to accept the lowest, or indeed any, tender unless they explicitly say so.
Okay, so that's the general landscape for ITTs. Adverts, shop displays, websites, auctions, tenders, usually just invitations. But, as we know in law, every general rule seems to have its compelling exceptions.
Always.
This is where it gets really interesting, because there are crucial scenarios where an ITT can actually be considered an offer. These are the ones you really need to watch out for.
Yes, these exceptions are vital to spot for the SQE. The most famous and important is the unilateral advertisement.
Unilateral meaning one-sided promise.
Essentially, yes. An advertisement can be a unilateral offer if it prescribes a specific act, the performance of which constitutes acceptance, and it demonstrates a clear intention to be bound by that performance.
And the classic case here is?
The one you absolutely must know. Carlyle v. Carbolic Smokeball Co.
Ah, the legendary smokeball case. It's such a powerful illustration. Tell us the story.
Okay. The Carbolic Smokeball Company, back in the late 19th century, advertised their product, a smokeball, claiming it would prevent influenza if used correctly.
Old claim.
Very. And to demonstrate their confidence and sincerity, they promised in the advert to pay £100, a lot of money back then, to anyone who caught the flu after using their smoke ball as directed for a specific period.
Okay, a promise of payment.
Crucially, they went a step further. They stated in the advert that they had deposited £1,000 in a specific bank account, specifically to show their sincerity and prove they meant business. This deposit was key.
Putting their money where their mouth was.
So Mrs. Carlyle bought the smoke ball, used it exactly as prescribed, and still got sick. She then claimed the £100 reward.
And the company?
The company, naturally, tried to argue the advert was just marketing puff, an ITT, not a binding offer. They argued she hadn't formally accepted, she hadn't notified them, all sorts of things.
But the court saw things differently.
They certainly did. The Court of Appeal held that the advertisement was a unilateral offer made to the world at large. Why? Firstly, the company's deposit of £1,000 in the bank demonstrated a clear, objective intention to be bound by their promise. It wasn't just puffery.
It showed seriousness.
Secondly, the advertisement prescribed a specific act using the product as directed and still getting sick as the method of acceptance. There was no need for Mrs. Carlyle to communicate her intention to accept before performing that act. Her performance was the acceptance.
So the act itself sealed the deal.
This case set a key precedent for when an advertisement crosses the line from an ITT to a binding unilateral offer. Other examples might include promises of a reward for finding a lost pet, £50 reward for finding Fluffy, or very specific buy one, get one free type offers that clearly state the terms and the act of acceptance, like presenting a coupon.
So the key is that clear objective intent to be bound, often shown by some action like depositing money, combined with the prescribed act for acceptance. What are some other exceptions to the general ITT rule?
Okay, another important one is in auctions without reserve. If an auction is advertised as being without reserve, this is generally treated as a unilateral offer by the auctioneer. It means the auctioneer promises to sell the item to the highest bidder, regardless of how low that bid might be. There's no minimum price. The act of making the highest bid is the acceptance of that unilateral offer to sell to the highest bidder, though the main contract for the item itself is still formed by the hammerfall.
Interesting distinction. What about tenders again?
Tenders. While the initial invitation is usually an ITT, if the invitation explicitly states that the person issuing it will accept the most competitive bid, for example, the lowest price for a service or highest for a purchase, or tenders that conform to very specific conditions that promise to accept the best conforming bid can sometimes be construed as a unilateral offer.
So the wording of the invitation to tender is crucial.
Absolutely. And perhaps the most common everyday exception, often overlooked: vending machines.
I never saw them that way.
They are classic examples of standing offers. The machine holds out goods for sale at a stated price. The terms are fixed. Putting your money in is the act of acceptance. There's no negotiation. Your act completes the deal.
Right. The machine can't then refuse to give you the chocolate bar. Unless it's broken, I guess.
Exactly. The contract is formed when you insert the payment.
That's a brilliant range of examples covering ITTs and their exceptions. Now, you've mentioned unilateral offers a few times, like with Carlyle and auctions without reserve. They seem distinct from the usual type. Let's make sure we clearly distinguish between bilateral and unilateral offers.
Certainly. It's a fundamental distinction. A bilateral offer is the most common type you encounter in everyday life and commerce. Think bi, meaning two. It involves promises on both sides.
A promise for a promise.
Exactly. It's an offer exchanged for a promise from the other party. For example, I promise to sell you my car if you promise to pay me £5,000. Both parties are making a binding promise to each other.
Okay, that's straightforward. So what's a unilateral offer again? Uni, meaning one?
Right. A unilateral offer, as we explored with Carlyle, is fundamentally different. It's an offer that can only be accepted by the performance of a specified act. It's a promise in exchange for an act.
Like the reward poster example.
Perfect example. I promise to pay you £100 if you find my lost dog. The offerer makes a promise, but the offeree makes no promise back. They accept simply by doing the requested act, finding the dog.
So one promise accepted by one action.
Precisely. And the key difference is that the rules governing acceptance and especially revocation, taking the offer back, are distinct for each type. We'll get into those details shortly.
Perfect. So we know what an offer is, what it isn't in ITT usually, and the difference between bilateral and unilateral types. Finally, for this section on offers, how does an offer become live or effective in the first place? Does it just exist once thought of?
No, absolutely not. There's a simple but crucial rule. An offer must be communicated to the offeree to be effective.
Communicated. So the person receiving it has to know about it.
Exactly. If the person you intend to make the offer to the offeree doesn't know about the offer, they can't possibly accept it. It's like trying to shake a hand you can't see. You can't agree to something you don't even know exists.
How can it be communicated? Does it have to be written?
Not necessarily. Communication can be made orally, face-to-face, phone, in writing, letter, email, text, or even implicitly through conduct.
Conduct. How would that work?
Well, think about the vending machine again. The machine's presence and display of goods is a communication of an offer through conduct. Or hailing a taxi, the driver stopping, is arguably acceptance communicated by conduct.
Right. And this communication rule is important for reward cases too, isn't it? If I find a lost dog and then see the reward poster?
Yes, that's a classic scenario. Generally, you can't claim the reward if you weren't aware of the offer before you performed the act, finding the dog. Your act wasn't done in response to the offer because you didn't know about it. You need knowledge of the offer for your actions to count as acceptance.
That makes perfect sense. Okay, that covers offers thoroughly, what they are, what they aren't, the different types, and how they must be communicated. Now, let's move to the other side of the agreement coin, the essential counterpart to an offer, acceptance. This is where the deal gets sealed, right?
Absolutely. Acceptance is the moment the contract springs into life. It's defined formally as a final and unqualified expression of assent to the terms of the offer.
Final and unqualified assent, so basically a clear yes.
In simpler terms, yes. It means the offeree agrees to the deal precisely, exactly, 100% as the offerer laid it out. No ifs, buts, or maybes, no changes.
And this is where the famous mirror image rule comes in, right? It sounds pretty self-explanatory, but what are its key implications?
The mirror image rule is fundamental to acceptance. It means your acceptance must be a perfect mirror image of the offer.
Reflecting it exactly back.
Precisely. Think of it like a puzzle piece. Your yes has to fit perfectly into the offer-shaped hole without altering anything. If you try to change even a single edge, add a condition, or tweak a term, it's no longer a perfect fit.
So it's not acceptance anymore.
Correct. It's not acceptance. It's likely a new proposal, a counteroffer, which we'll discuss more in a moment. So acceptance must accept all the terms exactly as they were offered.
Okay. And who can actually accept an offer? Can anyone just jump in?
No. Acceptance must always be made by the offeree, the person or specific group to whom the offer was addressed, or someone they've explicitly authorized to accept on their behalf. You can't accept an offer that was made to someone else.
Makes sense. And it has to be in response to the offer, like we discussed with communication.
Yes, absolutely. The acceptance must be made in response to that specific offer and with knowledge of it. You can't accidentally accept an offer you didn't know existed. It's also interesting to note, legally speaking, that the offeree's personal motive for accepting is actually irrelevant.
What do you mean?
As long as they know about the offer and genuinely agree to its terms, their underlying reason for doing so, whether it's for profit, out of necessity, or any other reason, doesn't legally matter for the validity of the acceptance itself.
So if I offer to sell you my vintage record player for £100 and you say, I'll take it, but only if you throw in that rare jazz album, that's not acceptance, even if you really want the player.
Precisely. That's not acceptance because you've altered the terms. You've added a new condition only if you throw in the album. It fails the mirror image rule. You haven't given a final and unqualified assent to my offer.
So what is it then, legally?
That would be a counteroffer. You've rejected my £100 offer and made a new offer back to me. Player plus album for £100. Now I can accept or reject your new offer.
Okay, the mirror image rule is clear. Now, the absolutely crucial part of acceptance is its communication. What's the general rule here?
The general rule is crystal clear and fundamental. Acceptance must be communicated to the offerer to be effective. This means the offerer must actually receive the acceptance. It has to land with them.
So just deciding in my head, yes, I accept, isn't enough.
Not nearly enough. The offerer needs to know you've accepted. Until they receive that communication, there's generally no binding contract.
And I've heard that silence generally isn't acceptance. You can't just assume someone's agreed if they don't reply, can you? That seems important.
You're spot on. Silence, generally speaking, cannot constitute acceptance. An offerer cannot simply impose a contract on the offeree by stipulating that silence will amount to acceptance.
Why not?
Imagine the chaos. If I sent you an unsolicited offer saying, if I don't hear from you by Friday, I'll assume you accept and the deal's done. That would allow one party to unfairly force a contract onto another simply through inaction. The law prevents this inertia selling.
Okay, so silence is out, usually. But acceptance doesn't always have to be in words, does it? Can it be through actions?
Absolutely. While silence usually doesn't count, acceptance can certainly be communicated by a third party if that third party is clearly authorized by the offeree to do so. And very importantly, acceptance can be communicated not just through words, oral or written, but also through conduct.
Acceptance by conduct.
Yeah.
That sounds interesting. Can you give us an example of how actions can speak louder than words in forming a contract?
A fantastic case example for this, often cited, is Brogdon v. Metropolitan Railway Co.
Okay, what happened there?
In this scenario, the parties, Brogdon, a coal supplier, and the railway company, had been doing business informally for years. They decided to formalize their arrangement. The railway company sent Brogdon a draft written agreement.
Right.
Brogdon made some minor amendments, signed it, marked it approved, and sent it back. The railway company's manager just put it in his desk drawer and never formally signed or communicated acceptance back to Brogdon.
So no formal written acceptance communicated.
Correct. However, both parties then proceeded to act entirely in accordance with the terms of that draft agreement. They ordered and supplied coal based on the prices and quantities in the draft.
Ah, so their actions followed the draft.
When a dispute later arose, the question was whether there was a binding contract based on that draft. The House of Lords held that yes, there was. Brogdon's return of the amended draft was arguably a counteroffer.
Okay.
But the railway company's subsequent conduct, placing orders consistent with the draft terms, constituted acceptance of that counteroffer by conduct. Their actions demonstrated their assent, even without a formal signature or explicit communication.
So continuing to perform the obligations showed they accepted the terms.
Precisely. Actions spoke louder than the lack of a formal signature.
That's a really important principle. But now, here's where it gets really interesting, I think. Because while the general rule demands clear communication of acceptance to the offerer, there are some very significant exceptions to consider.
Yes.
And these are often where SQE questions will try to trip you up.
Yeah.
Right?
They certainly will. These exceptions are crucial. Firstly, as we've already discussed quite a bit with Carlo, for unilateral offers, the performance of the specified act is the acceptance.
So communication isn't needed then?
Typically, communication of that acceptance to the offer is often waived or impliedly dispensed with by the nature of the offer itself. Performing the act is enough to form the contract unless the offer specifically asks for notification as well.
Okay, so unilateral offers are one exception. What else?
Secondly, there's a slightly nuanced point where if the offerer is at fault for not receiving the acceptance,
How so?
for example, if they know an acceptance is likely coming by email, but their server is down due to their own negligence, or their fax machine runs out of ink or paper,
Right.
they might not be able to claim no contract was formed simply because they didn't technically receive the acceptance due to their own fault, especially if the offeree reasonably believed they'd sent it correctly. The offerer can't benefit from their own mistake in preventing communication.
That seems fair. And then the big one, the grand exception, the one everyone talks about in contract law tutorials, the Postal Rule. This one always felt a bit counterintuitive to me. Why does it exist?
It does feel counterintuitive in our instant communication age, and it's definitely a product of its time, the 19th century, when post was slow and unreliable. The Postal Rule is an important historical exception to the general communication rule, that acceptance must be received.
So what does it say?
It states that for an acceptance sent by post, acceptance occurs at the exact moment of posting, provided the letter is properly addressed, stamped, and put into the control of the post office. For example, put into a Royal Mail post box or handed to an authorized employee.
The moment of posting, not delivery, not even when the offerer reads it.
Correct. The moment it's properly posted.
Wow. So if I drop that acceptance letter in the post box on Tuesday, the contract is formed then, even if you, the offerer, don't receive until Thursday.
Correct.
Or worse, if it gets lost in the mail entirely and never arrives.
That's the consequence, and it's precisely why it can feel counterintuitive today. Under the strict postal rule, the offerer cannot revoke their offer after the acceptance is posted, even if they haven't received it yet or even know it's coming. The contract is formed at the point of posting.
So the risk of the post being delayed or lost falls on
the offerer. The rationale was partly to provide certainty for the offeree once they've posted acceptance. They know they have a contract. It was also seen as fair because the offerer, by making an offer that could reasonably be accepted by post, implicitly accepted the risks associated with that mode of communication.
Okay, it makes a bit more sense in that historical context. Understanding this precise timing, the moment of posting, is absolutely critical.
Absolutely critical. Many problem questions hinge on knowing exactly when the contract was formed under this rule.
Are there other situations where the postal rule doesn't apply, even if the offeror hasn't explicitly ousted it?
Yes, there are several important limitations. The postal rule does not apply if the offeree is careless, for example, if they misaddress the letter or forget to put a stamp on it, causing it not to be delivered or delivered late. The rule presumes proper posting.
That seems fair. You can't rely on it if you messed up.
Right. Nor does it apply if it's not reasonable to use the post in the circumstances. For instance, if the offer was made by email or fax implying a similarly quick response as expected, using the post might be deemed unreasonable, so the postal rule wouldn't apply. Or if there was a postal strike happening, perhaps.
Context matters.
Context always matters. It also wouldn't apply if the original offer was made subject to a condition that acceptance must reach the offerer, even if not explicitly stated, or if applying the postal rule would lead to manifest inconvenience and absurdity, which is a broader legal principle courts sometimes invoke in extreme cases, though that's rare.
Okay, so the postal rule for physical mail has specific boundaries and can be excluded. What about the modern world? What about instantaneous communications like telephone calls, faxes, emails, or even interactions on websites? These are the norm now, not the exception. Does a postal rule apply there?
No, the postal rule generally does not apply to instantaneous forms of communication. For these methods, the general rule of acceptance applies, which is the receipt rule.
Receipt rule,
Meaning acceptance occurs when and where the offerer receives the communication. So if you accept by email, the contract is formed when the email arrives in the offerer's inbox, during business hours usually, not when you press send.
So the burden is back on the sender, the offeree.
Yes. The offeree is responsible for ensuring their acceptance actually reaches the offerer. If the email gets lost in cyberspace or caught in a spam filter the offerer never checks, then generally no contract is formed because acceptance wasn't received.
What if the offerer receives it but doesn't read it immediately? Like an email arriving at 3 p.m., but they don't check emails until the next morning.
That's a nuance. If the acceptance communication arrives within ordinary business hours and is available for the offerer to access, like sitting in their inbox, it's generally considered received then, even if they haven't literally read it yet. They generally can't just claim no contract exists because they hadn't opened their email, provided it was reasonable for them to check it.
Okay, so arrival in the inbox during office hours is usually enough. What if it arrives outside office hours? Say, an acceptance email sent at 11 p.m. on a Saturday.
In that case, it's generally deemed received at the start of the next working day, so 9 a.m. Monday morning, typically.
Right, and for website interactions, clicking I accept on terms and conditions or placing an order.
The receipt rule also generally applies there, unless the parties, especially businesses in B2B contracts, explicitly agree otherwise in their terms, perhaps an online order, and the automated acknowledgement of receipt are deemed received when addressed and available, irrespective of actual reading time, to streamline things. But the default is receipt.
That's a lot of nuance around how messages get sent and received. Okay, let's move on to something that often confuses people, especially in SQE questions. The difference between a counteroffer and a mere request for further information. These sound similar but have vastly different legal consequences, don't they?
This is an absolutely vital distinction, and yes, it's a common area for error in exams. They sound similar, but the impact is completely different.
So what is a counteroffer again, precisely?
A counteroffer is when the offeree responds to an offer, but instead of accepting it outright, the mirror image, they attempt to introduce new terms or change the existing ones. They're essentially saying, I don't accept your offer, but here's my proposal instead.
So not acceptance. And what's its crucial effect?
Crucially, a counteroffer destroys the original offer. It acts as a rejection of the original offer, meaning the original offer can no longer be accepted. That offer is dead, gone, off the table.
It kills it stone dead.
The counteroffer then effectively becomes a new offer made by the original offeree, who is now making an offer, to the original offerer, who can now accept or reject this new offer. The roles are reversed.
So if I say, I'll sell you my bike for 100 pounds, and you respond, great, I'll take it for 80 pounds, that original 100-pound offer is gone forever. You can't then immediately turn around 5 minutes later and say, okay, forget the 80 pounds, I'll pay 100 pounds.
Precisely. Your 80 pounds response was a counteroffer. It killed my original 100 pounds offer. If you then try to accept the 100 pounds, it's too late. My original offer no longer exists for you to accept. I might choose to make a new offer to sell at 100 pounds, but I'm not bound by the first one anymore.
And the classic case example for this?
The foundational case is Hyde v. Wrench. Wrench offered to sell his farm to Hyde for 1,000 pounds. Hyde, the prospective buyer, replied by offering 950 pounds instead.
A clear counteroffer.
Yes, Wrench refused this lower price of £950. Hyde then wrote back saying, okay, fine, I agree to buy it for the original £1,000.
So he tried to accept the first offer after his counteroffer was rejected.
Exactly, but Wrench now refused to sell at £1,000. Hyde sued. The court held that Hyde's counteroffer of £950 had destroyed Wrench's original offer of £1,000. It terminated it. So when Hyde later tried to accept the £1,000 offer, it was too late because that offer no longer existed, no contract.
Wow, that makes it so incredibly clear. A counteroffer kills the original offer, period. So then what is a request for further information, and how is it different? Why doesn't that kill the original offer?
A request for further information is distinct because it's simply an inquiry about the terms, or asking about flexibility, or clarifying a point. It does not introduce new terms or reject the original ones. Therefore, it does not terminate the original offer.
So the original offer stays alive.
Yes, the original offer remains open and can still be accepted after a request for information has been made and answered or even ignored.
It's about whether you're proposing alternative terms, counteroffer, or just asking questions about the existing ones, request for information.
Precisely. Look at the language used. Is it proposing a different deal or just seeking clarity on the current one?
Okay. Now, what about when businesses, especially large ones, are constantly sending each other their own standard terms of business? You know, the small print on the back of purchase orders and delivery notes, the famous battle of the forms. How does the law handle that clash?
Yes, this is a very common scenario in commercial practice, and it can get incredibly messy legally. It happens when two businesses try to contract and they each exchange their own standard terms and conditions.
So the buyer sends a purchase order with their T&Cs.
And the seller replies with an acknowledgement of order form or a delivery note that has their conflicting T&Cs printed on it. Both parties often proceed with the transaction, each assuming their terms apply.
So whose terms win? Is it the one who sends their terms first or last, or does it just become a mess?
It can become a mess, but the general rule applied by English courts is often referred to as the last shot rule.
The last shot.
Yes. This means the contract is generally formed on the last set of terms sent by one party before performance begins. For example, delivery of goods, starting work, provided the other party accepted those terms without objection.
How would they accept without objection? Just by carrying on?
Often, yes. Acceptance can be by conduct. So if the seller sends their terms last and the buyer then accepts delivery of the goods without protesting about the seller's terms, the buyer might be deemed to have accepted the seller's last shot terms through their conduct.
So the party who gets their terms in last, just before the action starts, often wins.
That's the traditional approach, yes. However, it's not always straightforward. Courts may also try to find a matching offer and acceptance earlier in the communication chain if possible. Or, if the terms are fundamentally contradictory on key points, they might look at the whole course of dealing, or revert to general contract law principles implied by statute, like the Sale of Goods Act, or in some cases, even conclude that no contract was formed at all if there's no clear agreement on the essential terms.
It sounds like the best advice is to make your terms clear and get the other side to explicitly agree to them.
Absolutely. Clarity and explicit agreement up front are always the best way to avoid these costly battles later on.
Okay, we've established what an offer is, how it's accepted or not. But offers don't just hang around forever waiting for acceptance, do they? They can disappear. Let's talk about termination of an offer, how an offer can simply cease to exist before it's accepted.
No, you're right. An offer isn't immortal. It has a limited lifespan. It can be terminated before it's accepted, and there are several ways this can happen, meaning no contract can then be formed based on that offer.
Okay, what's the most obvious way?
Firstly, and most obviously, by rejection from the offeree. If the person the offer was made to simply says, no thank you, the offer is terminated.
Straightforward rejection.
And as we've just discussed extensively, making a counteroffer is also a form of rejection, because by proposing new terms, you implicitly reject the original terms. So, counteroffer, rejection, termination of the original offer.
Okay, rejection or counteroffer by the offeree. What about if the person who made the offer just changes their mind? Can they simply revoke their offer? Take it back?
Yes, generally they can. The offerer is usually free to revoke or withdraw a bilateral offer at any time before it has been accepted.
Before acceptance is key.
Absolutely key. Think of an offer as an open hand held out for a handshake. The offerer can pull that hand back any time before the other person actually grasps it in acceptance.
But how do they pull the hand back effectively, just thinking it isn't enough?
No. Here's the crucial part about revocation. Revocation must be communicated to the offeree to be effective. Pulling your hand back in your own head or telling someone else you've changed your mind isn't enough. The offeree has to receive notice that the offer is off the table.
How can that communication happen? Does the offerer have to tell them directly?
Direct communication is clearest, e.g., phone call, email saying, "I withdraw my offer." But communication can also be effective if it comes from a reliable third party. For example, if I offer to sell you my car, but before you accept, your reliable friend tells you they just saw me selling the car to someone else, that communication from the third party could be effective revocation. You now know the offer is gone.
Okay, so communication is key. And crucially, you mentioned earlier, the Postal Rule does not apply to revocation.
Correct. This is a vital difference from acceptance under the Postal Rule. Revocation is only effective upon receipt by the offeree. It doesn't matter when the offerer sent the revocation letter or email. What matters is when the offeree actually receives it.
That's a really important distinction for timing and problem questions. So let's recap that timing point. If I post an offer to you on Monday, and then I post a letter revoking that offer on Tuesday morning, but before my revocation letter arrives, you post your letter of acceptance on Tuesday afternoon, is there a contract?
Yes, there would be a contract in that scenario. Here's the timeline. 1. Monday, your offer is sent. 2. Tuesday morning, you post revocation, ineffective until received. 3. Tuesday afternoon, offeree posts acceptance. Under the Postal Rule, acceptance is effective now, contract formed. 4. Wednesday, say, offeree receives your revocation letter. Too late. The contract was already formed on Tuesday afternoon.
Well, the timing is everything. So acceptance can beat revocation if it gets posted first.
Exactly, because of the different rules governing when each becomes effective. Posting for acceptance, receipt for revocation. It's all about precise timing and applying the specific rules for offer, acceptance, and revocation communication.
Got it. That's for bilateral offers. What about revoking unilateral offers like the car lil smoke ball or the lost dog reward?
Oh.
Is that easier or harder?
Generally, it's considered more complex and potentially harder to revoke a unilateral offer effectively, especially once performance has begun.
Why is that?
Because the law tries to be fair to the offeree who might have already started performing the requested act in reliance on the offer. The general principle is that an offerer cannot revoke a unilateral offer once the offeree has started to perform the specified act.
So if someone starts actively searching for my lost dog, based on my reward poster,
Yeah.
spending time and maybe money on travel,
You might not be able to revoke that offer mid-performance just before they find the dog. The law implies a secondary promise not to revoke once performance has commenced, as long as the offeree continues to perform. It protects the person who has already begun their part of the deal.
that seems fair. How must revocation of a unilateral offer be communicated then? Especially if it was made to the world at large, like an advert.
Good question. Communication of revocation for a unilateral offer generally needs to be done using the same method, or a method with similar prominence, as the original offer.
So if the original offer was a big newspaper advert,
You would generally need to revoke it through a similar newspaper advertisement to reasonably bring the revocation to the attention of those who might have seen the original offer and be acting upon it. You can't just quietly take down a notice in one shop if the offer was advertised nationally. It needs comparable publicity.
so once someone begins to act on a unilateral offer, it becomes much harder to pull back, and revocation needs to be just as public as the offer. What are the other ways an offer can simply terminate without either party actively rejecting or revoking? Can it just expire?
Yes, an offer can also terminate by lapse. It essentially dies of old age or changing circumstances.
How does that happen?
Firstly, through the passage of time. If the offer itself specifies a time limit, example, this offer is open until 5 p.m. Friday, it automatically lapses at that exact time if not accepted beforehand.
And if no time limit is set,
If no specific time limit is set, the offer will lapse after a reasonable time.
how long is a reasonable time? A day? A week? A year?
It depends entirely on the context. It's determined by the specific circumstances of the offer, the nature of the subject matter, for example. An offer to buy perishable goods like strawberries might lapse very quickly, perhaps hours, whereas an offer related to land might remain open for longer. Market conditions also play a role. An offer to buy shares at a specific price might lapse quickly in a volatile market. It's what's reasonable in that specific situation.
Okay, so lapse by time. What else?
An offer can also lapse due to the death of the offerer. However, this is slightly complex. If the offeree has notice of the offerer's death before accepting, the offer generally lapses, especially if the offer involved personal services that only the deceased could perform, like painting a portrait.
What if the offeree accepts without knowing the offerer has died.
If the offeree accepts in ignorance of the death and the contract is not for personal services, for example, an offer to sell goods, it may still be possible to form a binding contract with the deceased offerer's estate. But the law is a bit uncertain here.
Tricky. What about the death of the offeree?
That's simpler. An offer will always lapse on the death of the offeree. The offer was made to them personally, and no one else, like their executor, can accept it on their behalf after they have died.
Makes sense. Any other ways an offer can lapse?
Yes, finally, an offer can lapse due to the non-fulfillment of a condition precedent. If the offer was made subject to a specific condition being met before acceptance is possible.
Like,
For example, an offer to buy a house subject to obtaining satisfactory financing, or an offer to hire someone subject to receiving positive references, or an offer to buy a car provided it passes its MOT test. If that condition is not met, financing refused, references are bad, car fails MOT, the offer simply lapses automatically. The condition wasn't satisfied, so the offer dies.
okay, so termination can happen through rejection, counteroffer, revocation, or lapse due to time, death, or failure of a condition. That covers the main ways an offer ends before acceptance. And just a quick mention of option contracts. I know these come up occasionally as a way to keep offers open. How do they work?
Right. An option contract is a way to combat revocation. It's a distinct, separate, binding contract about the main offer.
A contract about a contract.
Essentially, yes. In an option contract, the offerer agrees to keep their main offer open and irrevocable for a specified period in exchange for something of value, typically a small payment or some form of consideration from the offeree.
So I pay you £10 to keep your offer to sell me your car for £5,000 open for 1 week.
Exactly. That £10 payment or other consideration makes your promise to keep the main offer open legally binding for that week.
Yeah.
You cannot revoke the £5,000 offered during that period. It effectively buys the offeree time to think or arrange funds, knowing the offer is safe.
But it's crucial to remember it's a separate contract that needs its own agreement, consideration, and intention.
Absolutely. It sits alongside the main offer, guaranteeing the main offer stays open for the agreed time.
Okay, brilliant. So we've thoroughly covered the foundational elements of offer and acceptance. This has been a whirlwind tour of contract formation. Now, let's try and bring it all together with some practical SQE assessment advice, and then the moment you've been waiting for, test your knowledge with some multiple choice questions.
Sounds good. Your real challenge isn't just knowing the rules, it's being able to apply these principles to different factual scenarios, often complex ones presented in MCQs.
So what skills do they really need to demonstrate?
It means confidently distinguishing a genuine offer from a mere invitation to treat. That's often the first step. Differentiating between bilateral and unilateral offers, and knowing their distinct rules for acceptance and revocation. Understanding the various methods of communicating offers and acceptance, and, crucially, when they become legally effective, especially mastering the Postal Rule and the receipt rule.
And spotting those counteroffers versus requests for information.
Absolutely. Spotting the difference and knowing the effect of counteroffers kills the original offer versus simple requests for information leaves the original offer open. And finally, being able to identify how and when offers are terminated, rejection, revocation, lapse. You need to be methodical.
To help you be methodical, our sources provide a really useful checklist for tackling an MCQ on contract formation. Let's walk through these systematic steps, which can be a real lifeline under exam pressure.
Okay, step 1. When you first read the MCQ scenario, immediately consider the essential elements required to form a legally binding contract. Does the question primarily involve issues of offer, acceptance, ICLR, capacity, or maybe a combination? Start by identifying which of these pillars are relevant to the facts presented.
Step 2. If there's a potential contract in the scenario, is it a valid offer in the first place? Think. Is it clear and certain? Was it properly communicated to the specific offeree? And importantly, check the timeline. Has it been rejected, revoked, or lapsed before any purported acceptance occurred? Rule out any invalid or terminated offers right away.
Step 3. For any valid offer you've identified that hasn't been terminated, now consider whether anyone has accepted it. Was the response a valid acceptance? Remember the mirror image rule. Did it accept all the terms exactly without changes? Was it made by the correct offeree and clearly in response to that offer? And critically, was it effectively communicated to the offerer?
And this is where you really need to apply the communication rule.
Was communication required? If so, was it received? Receipt rule for instantaneous methods? Or does the postal rule apply, effective on posting? Remember the exceptions and how the offer itself might modify the rules. Acceptance must be received.
Step 4. Okay, offer and acceptance checked. Next, quickly check for capacity and ICLR. Do the parties involved, individuals, companies, actually have the legal capacity to enter into this contract? Are there any issues with minority or mental capacity mentioned? And then, critically, apply the presumptions for intention to create legal relations.
Is it a social domestic agreement? Presumed yes, ICLR. Based on the facts given in the scenario, is there anything specific that might rebut that starting presumption? Look for clues in the relationship and the formality.
Step 5. Finally, if the scenario presents multiple potential contracts or a series of back-and-forth communications, especially if it involves the sale of the same item to different people, you need to systematically determine which, if any, contract was truly formed first. Pinpoint the exact moment a valid offer was validly accepted according to the rules. The first valid contract formed will usually be the binding one.
This systematic approach, offer, acceptance, capacity, ICLR timing, will help you break down even the most complex SQE scenarios into manageable parts and arrive at the correct legal conclusion.
All right, deep diver, it's time to put that checklist into practice. Let's test your knowledge with some SQE-style MCQ questions based on what we've covered. Ready?
Let's do it.
Here's MCQ 1, focusing on offer versus ITT.
Scenario. A shop window displays a designer handbag with a price tag clearly showing £500. Clara enters the shop, picks up the handbag, takes it to the counter, and states to the shop assistant, "I accept your offer to sell this handbag for £500. The shop assistant apologizes and refuses to sell it, stating it was accidentally mispriced by a junior staff member and the actual price should be £1,500.
Has a legally binding contract been formed between Clara and the shop for the handbag at £500?
Yes, because Clara accepted the shop's clear offer displayed in the window at the stated price. B. No, because the display of goods in a shop window is generally an invitation to treat, not an offer. Clara made the offer at the counter, which the shop assistant rejected. C. Yes, because the price was clearly displayed, indicating a firm offer to sell at that price. D. No, because Clara did not provide consideration payment at the exact moment she stated her acceptance.
Okay, take a moment. Think about shop displays, ITT or offer. Who makes the offer where?
Right. The correct answer here is B. Remember our core principle. The display of goods in a shop window or on shelves is generally treated as an invitation to treat, not a binding offer to sell.
So the shop isn't offering, it's inviting offers.
This means the shop is inviting customers like Clara to make offers to buy the items. When Clara took the handbag to the counter and said she'd buy it for £500, she was making the offer.
And the shop assistant?
The shop assistant, acting on behalf of the shop, was then perfectly entitled to either accept or reject Clara's offer. In this case, due to the mispricing, they rejected it. Since Clara's offer was rejected, no contract was formed at the £500 price. Option D is incorrect because consideration comes later. The issue here is lack of agreement, offer, and acceptance.
That's a very common scenario and a fundamental point. Well done if you got that right. Next up, MCQ 2, testing your understanding of counteroffers.
Scenario. David sends an email to Emily offering to sell his unique vintage car to her for £20,000. Emily replies by email, "That's a bit high. I will buy your car for £18,000. David emails back saying, "No, that's too low." A few hours later, Emily sends another email. "Okay, you drive a hard bargain. I'll pay the full £20,000 after all." David now refuses to sell the car to her, having received interest from someone else.
Is David legally bound to sell the car to Emily for £20,000?
Yes, because Emily eventually accepted the original offer price of £20,000. B, no, because Emily's counteroffer of £18,000 terminated David's original offer of £20,000, so it could no longer be accepted. C, yes, because David's original offer was still open until he explicitly revoked it or sold the car elsewhere. D, no, because Emily did not communicate her final acceptance effectively within a reasonable time.
Okay, think back to Hyde v. Wrench for this one. What happens when a counteroffer is made? Does the original offer survive?
The correct answer is B. This is a direct application of the Hyde v. Wrench principle. A counteroffer completely destroys the original offer.
So Emily's £18,000 email wasn't just a negotiation.
No, by saying, "I will buy your car for £18,000, she wasn't just asking. She was making a definite counterproposal. This action immediately terminated David's original offer of £20,000. It ceased to exist legally at that point.
So when she later tried to accept the £20,000...
It was too late. The offer she was trying to accept was already dead, killed by her own counteroffer. David was no longer bound by that initial £20,000 offer and was free to refuse to sell to her or sell to someone else. Her final email was, in effect, a new offer to buy at £20,000, which David was free to reject.
Crucial point about counteroffers killing the original. All right, one more for the road. MCQ 3, focusing on the Postal Rule and revocation.
Scenario. On Monday, Sarah sends an offer by post to Ben to sell her antique guitar for £300. The letter arrives on Tuesday morning. On Tuesday afternoon, Ben posts a letter back to Sarah, properly addressed and stamped, unequivocally accepting her offer. Later on Tuesday evening, before receiving Ben's letter, Sarah changes her mind and posts a letter to Ben revoking her offer. Ben receives Sarah's revocation letter on Wednesday morning. Sarah receives Ben's acceptance letter on Wednesday afternoon.
Is there a binding contract between Sarah and Ben for the guitar?
No, because Sarah revoked her offer before she received Ben's acceptance letter. B, yes, because Ben's acceptance was effective when he posted the letter on Tuesday afternoon, which was before Sarah's revocation was communicated to him on Wednesday. C, no, because the postal rule only applies if the acceptance letter is actually received by the offerer. D, yes, but only if Sarah's original offer explicitly stated that acceptance could be by post.
Okay, this one is all about precise timing and knowing the different rules for when acceptance by post becomes effective versus when revocation becomes effective. Think carefully about Tuesday afternoon versus Wednesday morning.
The correct answer here is B. This scenario perfectly illustrates the interplay between the postal rule of acceptance and the receipt rule for revocation.
Let's break it down. When did acceptance happen?
Under the postal rule, which applies here as there's no indication it was excluded and using post seems reasonable, Ben's acceptance was legally effective at the precise moment he posted his letter on Tuesday afternoon. A binding contract was formed then.
Even though Sarah didn't know about it, yes.
Yes. That's the effect of the postal rule. Now, what about Sarah's revocation?
She posted her revocation letter later on Tuesday evening.
But revocation, unlike acceptance under the postal rule, must be communicated to the offeree to be effective. Communication means receipt. Ben only received Sarah's revocation letter on Wednesday morning.
So the contract was already formed before the revocation took effect.
Since the contract was already formed on Tuesday afternoon when Ben posted his acceptance, Sarah's later attempt to revoke her offer, which only became effective on Wednesday morning, was too late and legally ineffective. There is a binding contract. Option C is wrong because the postal rule makes acceptance effective on posting, regardless of receipt, unless ousted. Option D is wrong because the postal rule can apply even if not explicitly stated, provided it's reasonable to use post.
Excellent. A great test of applying those timing rules. Hopefully, working through those NCQs helps solidify the principles, deep diver. You're building that legal understanding brick by brick, especially for those of you joining us without a traditional law background. Remember, law isn't just about memorizing dry rules from a textbook.
Definitely not.
It's about being able to skillfully apply those rules to real-world facts and complex scenarios, just like in those MCQs. And by working through these examples and landmark cases like Carlisle and Hyde v. Wrench, you're gaining a truly practical edge. We highly encourage you to go back, review your own materials, maybe re-listen to parts of this, practice even more questions, and keep asking what if to really solidify your understanding.
Yes, the more you apply these concepts, the more intuitive they'll become. Keep practicing.
Absolutely. That's all for this deep dive into contract formation. Until next time.